Imagine stepping into your dream home, a place filled with charm and history. But soon the walls start whispering and strange shadows dance in the corners. You can't help but wonder, is this place haunted? Now, what I can tell you is we can't write a title policy for a ghost. And if an actual ghost is telling you they own the land you just bought, you probably won't have to call us to go to court on your behalf. You might have to call the Ghostbusters. With all that being said, a cloud on title is very much so like a haunted house. Just as ghosts conceal their stories, a property can hide a dark past beneath its surface. You are not just buying a home, you're inheriting its entire history, some of which might come back to haunt you. In the realm of real estate, hidden title issues can emerge at the worst moment, causing financial nightmares. I'm Ashley Scipioni, certified fidelity Ghostbuster, and someone who has dealt with all types of strange clouds on title. In this episode, I want to go over some particularly unique or strange instances that can come up on your journey to home ownership, and clarifying how to clear up a cloud on title. Scenario 1, divorce. Unfortunately, divorce is all too common in today's society. While it's a nightmare to go through, the cloud in the chain is unrecognizable until you are in its midst. Example, judge orders for the ex-husband to quitclaim deed a property to the ex-wife. That step never happens. Instead, the wife later goes to refinance the home or to sell it, and title discovers that a quitclaim deed from the ex-husband is still necessary. At this point, the ex-husband is either MIA or is not as inclined to assist. He may demand payment, which legally he is not entitled to, but in an effort to close, the wife may have to pay him. Further, if the ex-husband isn't paying his child support, a child support lien may have been filed and attached to the property since he was still the legal owner. Now what is this mom supposed to do? Is she going to proceed with closing and pay herself off in order to clear the judgment, or is she going to have to change all of her plans? Scenario 2, probate. Now this scenario has dozens of different outcomes, but in this example, probate was actually filed, which is step 1. The partner is now selling the property since he was gifted it through her will. The title company gets their commitment and it calls for them to obtain certified copies of the probate documents and file them in public records. Simple, right? Unfortunately, once the documents arrived, the title agent discovered that the probate was done wrong. They filed it as her homestead property, which avoids all creditor claims. But truth be told, he was not her husband. He was her partner for 30 years. While that is impressive, it does not negate the fact that they should have filed notice and given creditors an opportunity to submit their claims for payment from the estate. Literally the day of closing, the 30-year partner was faced with 2 scenarios. Either refile probate correctly and delay closing for 60 to 90 days, or pay every potential creditor at closing from the proceeds. Neither are great options, but what can you expect from those pesky ghosts? Scenario 3, ladybird deeds. This one relates back to my last scenario a bit. However, that is not what the seller expected. In this scenario, the owner of the property hired an attorney to prepare a quitclaim ladybird deed to the love of his life. While they were not legally married, should anything happen to him, he wanted the property to go to his lady Joanne. Now that he has passed away, his Joanne is trying to sell the property. Unfortunately, in the title search, it was discovered that the attorney prepared the deed incorrectly. Instead of transferring a remainderment interest to Joanne, he kept his fee simple interest and transferred her a life estate interest. Essentially, that meant she had an interest in the property as long as she was alive, but did not gift her the property in his passing. Now, probate is required for the seller. His heirs have to sign and are entitled to half, and Joanne has to sign and will receive the other half. Scenario 4, family and generationally transference. A great-great-grandson decides he is tired of living on his family's estate and cannot pass up the opportunity to sell it for a pretty penny. He lists the property and quickly goes under contract. The title search, which typically takes 3 to 5 days to complete, ends up taking over 3 weeks. The family never formally or legally transferred ownership. It just passed from parent to child, generation after generation. Since proper probate proceedings were never done, and since so many people were deceased, the only option for this great-great-grandson was to file a quiet title action with the court so they could deem him the official owner of the property. Unfortunately, he did not have the means to hire an attorney or go through proper court proceedings, and the transaction fell apart. Obviously, there are simpler examples of chain of title issues that are all very common. They include quitclaim deeds in the chain that were done with wrong legal descriptions, missing marital statuses, wrong legals, and improper executions, which could mean the wrong notary acknowledgement or even a lack of witnesses. We've seen a lot of properties with quitclaim deeds that are missing any proof of authority for entity signers, or even a lack of supporting documents such as trust documents or recorded power of attorneys. All that to say, you never know when you have a haunted chain of title, so be sure to call the experts at Fidelity for your real estate transactions, the unofficial Ghostbusters of title. Thank you for watching my 5th masterclass for the reframe. Be sure to follow us on Instagram, Facebook, and LinkedIn at The Reframe F&T for more thought leadership from me and my counterparts, Susan West and Jesse Pittman. And as always, let's work smarter, not harder.